Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. I've been pleasantly surprised by how some of the courts in the Northeast have been sort of taking care of defendants in cases where there is some doubt as to whether or not statements that they've made or other actions have been done voluntarily and knowingly. Because particularly when you waive a statutory or constitutional right, you absolutely have to do it with full knowledge of what the consequences of that are. So this is a case of the state of Connecticut versus Larice King. And it's an interesting case. Let's take a look. The state filed a substitute information charging Ms. King with the crime of unaliving someone as an accessory and for conspiracy to commit murder. They brought it to the Superior Court in the Judicial District of Fairfield and tried it to a 3-judge court. We'll find out why in a little bit. And as a result, the court denied the defendant's motion for an acquittal. There was a trial, and Ms. King was convicted. In Connecticut, as in all states in the Union, defendants facing serious criminal charges enjoy the constitutional right to a trial by a jury. A fundamental decision about the exercise of official power, a reluctance to entrust plenary powers over the life and liberty of a citizen to one judge or a group of judges. In other words, the reason that the right to jury trial exists is because you don't want one person making that call. Notwithstanding the silence of these constitutional provisions on the subject, the United States Supreme Court has always interpreted the right to a trial by jury to include the unmistakable requirement that a unanimous jury verdict occur before a defendant may be found guilty. Defendants can waive this constitutional right and instead elect to a trial before a court. The trial court must find, when they do this, that the waiver is knowingly, intelligently, and voluntarily made. Most cases involve a trial before a single judge. So if you have a misdemeanor or a minor felony, these can be tried in front of a one-judge panel. Most cases in which a defendant waives the right to a trial by jury result in a trial before a single judge. Connecticut, however, provides a distinct alternative in one category of cases. By virtue of 2 statutory provisions, when a defendant is charged with any crime punishable by life imprisonment, with or without the possibility of parole, and elects a court trial, the court shall be composed of 3 judges. Such judges, or a majority of them, shall have the power to decide all questions of law and fact arising upon the trial and render judgment accordingly. Our research has shown that these statutes are unique among the 50 states because they require only 2 of the 3 judges to arrive at a verdict and render judgment. In Ohio, you can have a 3-judge panel, but it has to be unanimous. In Connecticut, the 3-judge panel does not have to be unanimous. In the present case, defendant Larice King waived her right to a jury trial and elected to be tried to a 3-judge panel on charges of unaliving this person. The 3rd member of the court, Richards, dissented and instead would have found the defendant guilty of accessory to a different crime in the 1st degree as a lesser included offense. So the defendant appeals, and the only thing we're really interested in here is the failure of the trial court to explain that the 3-judge panel did not have to reach a unanimous decision, rendered her jury trial waiver involuntary, and thus was unconstitutional. The court is actually not going to deal with the constitutional claim. It's going to take a shortcut, and we'll see why in a moment. Although we conclude that the sufficiency of the evidence is there, we hold the trial courts must canvass defendants who choose to be tried before a 3-judge panel, that although a jury of their peers must be unanimous, the 3-judge panel can properly arrive at a guilty verdict by a majority vote. So here are the pertinent facts. The defendant, King, was married to the victim, Dathan Gray. They'd had a turbulent relationship. They were separated for about 2 years. Both of them were dating other people. And at one point, the defendant posted something on Facebook that alleged that she would kick Gray's hind end whenever she saw him, and that whatever my family do to you is beyond me, they tired of you. Now, down here in the South, we might refer to Ms. King as a scrapper. But of course, in Connecticut, they'd refer to her as a scrapper. You know, the guy like the guy in The Pepperidge Farm remembers commercials. They don't have any R's at the end of their words up there. Anyway, on the night of July 26, 2019, Gray was working a shift at the Snack Shack in Bridgeport. His supervisor called King, his wife, and said, "Come take care of him. He's drunk and he's acting up." So the defendant and her best friend drove over there, and they got into a bit of a tussle, but nothing bad happened that day. Then about 1 a.m. on July 27th, Gray and his girlfriend, a gal by the name of Zachariel Beverly, were talking on the sidewalk down the street from the Snack Shack when two guys came up basically in hoodies and did some violence to him that wound up in him no longer being with us. This happened at 1 a.m. in the middle of the evening, or the middle of the night really, middle of the morning maybe. And I've always wondered why people are out on the streets at 1 o'clock in the morning. I have never seen anything good come of being out on the street at 1 o'clock in the morning. In fact, when I worked as a respiratory therapist and did a lot of work at nights in the emergency room, that seemed to be the time we got all the shootings and stabbings and that sort of thing. Nothing good happens to you when you're out playing around at 1 o'clock in the morning. Interestingly enough, it was pretty clear to the people who witnessed it that it were two men wearing hoodies who did this killing. As a result of that, the police started looking at surveillance footage in the area around, and they found that Ms. King was actually in an SUV, and that she picked up these two men and took her two friends somewhere else. The car belonged to one of her cousins, and as a result, they indicted one of the people who did the shooting. By the way, Mr. Gray was penetrated 11 times by 11 different rounds. So the two people who did this unaliving were very thorough at it. So they talked to her, they questioned her, she lied to the police, and as a result, they filed charges and went up to take her before the court and try her. Now, so Ms. King challenged the sufficiency of evidence at her trial because her face was not visible on the surveillance. It was her cousin's car, but she had admitted to wearing an outfit that was described and could be seen in the video, but she still felt that there wasn't sufficient evidence. The court decides pretty easily that there was plenty of sufficient evidence to convict her as presented at trial. But that wasn't the key question. The question was whether she had knowingly and intelligently waived her right to a trial by a jury. They will essentially conclude that she hasn't. So they go before the court, and the court says, "I understand the defendant was here with the possibility of waiving her right to a jury trial." The lawyer says, "Yeah, I don't know what I could tell her she'd ever have a jury trial." And they were worried basically about the delays caused by COVID. She's in jail. It's 2020. She's been in there for several months. She doesn't know when there's a possibility of getting out of jail. And as a result, she's pretty upset about being in jail, as you might imagine. So she essentially decides, in order to get out of jail and get a trial with some alacrity, that she will waive her right to a jury trial and have it tried in front of a 3-judge panel. After canvassing the defendant about her decision to reject the state's pretrial offer, during which the court asked her about her background, education, and work experience, the court then canvassed the defendant specifically about her decision to waive her right to a jury trial. He says, "Now, statutorily, and you have a constitutional right to what we call a trial by jury. A jury of your peers, ma'am, or we'll go through the process of selecting a jury. A trial will be presented before a jury will deliberate and arrive at verdicts. I don't know what those verdicts would be. Those verdicts could be guilty, they could be not guilty, or they could be a mix of the two. Do you understand that?" She says, "Yes." "Now, you do have a constitutional right and a statutory right, ma'am, to a trial by jury. Do you understand that?" "Yes." "Similarly, you have a right to waive that jury trial, and you could elect for what's called a courtside trial. A courtside trial does not involve jurors, as you and I typically understand that. It would involve what we call a 3-judge panel. 3 Superior Court judges would sit as jury, and they would have evidence presented before them and would arrive at verdicts, and they would perform a sentencing if any of the verdicts resulted in a verdict of guilty. Do you understand that?" She said, "Yes, I do. But there's something important here." Did you see what the court said? The court said, the judges would sit as a jury. A reasonable person hearing those words would think, okay, that means the judges have to be unanimous in their decision. But Under Connecticut law, they don't have to be. And this is where I think this word right here would sit as a jury. Those words are what else essentially undoes this case. So having already talked to her about her age and education and work background, he says, I don't have to ask you about that, but I do have to ask you, would you rather have a trial before a 3-judge panel? She said, I would waive the jury trial. I would rather have the 3-judge panel. All right, you've had enough time to discuss that with your attorney. Yes, I have. The court says, now, Attorney Peck, I turn to you, sir, and I ask you, have you consulted your client, has consulted with you on this issue? Are you satisfied, sir, that she understands the election that she's made? He says, I'm satisfied that she's making the election knowing and voluntarily. All right, anything further from the state? No. So then they certify the trial, and they have the trial in front of the 3-judge panel. And of course, as a result, she is convicted. And then they bring this claim for essentially the trial court not doing what it should have done and explaining that the 3-judge panel doesn't have to be unanimous. So the appellate court goes through some of its prior case law. In the absence of a written waiver, trial courts must canvass defendants on the record and confirm that any jury trial waiver is knowing, intelligent, and voluntary. A canvass for a jury trial waiver need not be extensive, but competent counsel is capable of explaining the basic differences. But how do you know that they've explained them if, in fact, the court doesn't inquire? It says, then finally, although not constitutionally required, we recommend that our trial courts elicit from a defendant proper assurances that he or she, in fact, understands the differences between a jury trial and a trial to a court. The present case required a more particularized judicial explanation of the right being waived. She was presented with the choice between electing a trial before a 12-member jury that would have had to arrive at a unanimous verdict to find her guilty, or a trial before a 3-judge panel that would find her guilty, as they did here, if only 2 of them agreed. So one of the things that the court did here, and I think it's really interesting, is that they went through a lot of cases where they found that their trial was to a 3-judge panel, and they sent people out to the courthouses to pull the transcripts and look and see what the colloquy was between the judge and the defendant. They found only 7 similar cases in the entire state, and of those 7 cases, in 5 of them, the court went to the extent of saying, look, you understand that the 3-judge panel does not have to be unanimous, but a jury has to be unanimous, and they found that particularly interesting. So the way they got around dealing with the constitutional issue here said, we're going to exercise our supervisory authority over the courts. In other words, we're going to initiate a new rule for all of our trial courts in the state. Trial courts, pay attention. This is what you have to do from this point forward. Specifically, what you have to do from this point forward is you must tell the defendant that in addition to not getting a jury that is before a 3-judge panel, that the 3-judge panel can render a verdict without it being unanimous. And so, without dealing with the constitutionality of that aspect of the case, they essentially kind of prevent the United States Supreme Court from getting into it. And they also base it on the Connecticut Constitution, which gives them this supervisory authority. Now, Ms. King probably doesn't matter to her one way or the other how they reach this issue. Basically, she gets another trial and another bite at the apple to perhaps be forgiven for having done what she did. And as often happens in cases like this, particularly where it's an old case, the evidence may not be as fresh as it was. Some of the people may have changed their story over time. Some of them may not remember what they said at trial the first time. The state might very well offer her a deal, something like time served plus a year and let you out, because she was convicted by the one lone dissenting judge of a lesser included offense, which might have resulted in a much shorter sentence than 50 years, which is what the trial court gave her. So, in that situation, it's not like a complete win, but rather it's more like a partial victory that she will be able to exploit to her benefit. So that's what I have for you today. As always, I'd love to hear your thoughts on this. Did the court reach the right decision? Tell me what you think. I would love for you to give me a like on this video if you enjoyed it. And if you haven't already subscribed, well, I'd love for you to do that too. You can email me at the address above. It's right up there, aldewit7@gmail.com. So if you don't want to share something publicly, you can drop me a note there. One thing that I ask at the end of all these videos is that you make somebody else's day better today by doing a kindness. Doesn't have to be a big thing, just make somebody smile. I'll be back here at the beach tomorrow with another video. Until then, stay safe, stay legal, stay informed. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.